All right, Mr. Glazer, are you ready to proceed with Mr. Carter?
Yes, Your Honor.
This is file 25-22166-FH People versus Brendan Jamal Carter. We are here today for sentencing in this case. We're proceeding today by video conference. First, can I have Mr. Glazer place your appearance on the record?
John Glazer on behalf of the defendant, Your Honor.
And sir, you are Brendan Jamal Carter?
Yes, sir.
Mr. Carter, have you had an opportunity to read and review your pre-sentence report?
Yes, I did.
Have you had an opportunity to discuss that report with Mr. Glazer?
Yes, sir.
Are you satisfied with Mr. Glazer in the advice that he's given you?
Yes, sir.
Do you wish to explain or challenge the accuracy or relevancy of any of the information that is in your pre-sentence report?
I was just reading over it, and it said something about completing education basically when I graduated high school over 10 years ago. So I was just trying to figure out what that was about. And then I received my associate degree in accounting from LCC as well, directly after high school. So I wasn't sure what she meant by complete high school or education basically. And then something about a drug program and stuff like that. I don't use any type of drugs, basically.
Mr. Carter, I'm sorry to interrupt you. I'm having a really difficult time understanding what you're saying because your microphone or your voice is so quiet. Can you speak a little louder, please?
Your Honor,
Sorry
Your Honor, I think those are things we need to address in the sentencing. As to the facts of the PSI, you don't have any question, state or nothing in there is wrong. Is that correct?
Oh, yeah, no, nothing wrong.
Judge, if they don't bring in verification of education or employment, we have to say that even though it's in the facts, it's in the report that he did get the schooling he said he did. But the one part I have to say, he didn't have it because he didn't verify it.
Where is that located?
That's number 6, Your Honor.
Oh, I'm sorry, in the recommendation portion.
Yeah, that's what I said. We were going to address it.
Okay. All right. I understand.
If he verifies his education, I have no problem with that.
Gotcha. All right. Mr. Glazer, does the pre-sentence report disclose any prior convictions in which there exist any known constitutional defects?
No, Your Honor.
And probation officers calculated the minimum sentencing guidelines to be from 0 to 3 months. Do you agree with that computation guidelines?
Yes, Your Honor.
Is there anything that you want to say on behalf of Mr. Carter before the court passes sentence, Mr. Glazer?
Your Honor, he wants to apologize for this incident happening. He will make every effort to pay off that restitution. He asked me what happens if he can't get it done within the 2 years. I told him then the court could extend it out, but he's going to make every effort he can to do that, and then to pay off his fines and costs. As he's just previously indicated, he was wondering about the enrollment. He's completed high school. He graduated 10 years ago and's got an associate's degree on top of that. And his other question was about drug testing or about drug programs. And I told him, if I'm reading this right, it's just that they might ask him to take a test, but he doesn't have any drug problems. I can't imagine he's getting ordered to go into any drug programs, but those are the only 2 concerns he had.
Okay. Mr. Carter, is there anything you'd like to say on your own behalf before the court passes sentence?
Uh, no, sir. I do apologize, like I said, for wasting the court's time, and I am going to make a sincere effort to pay off my restitution and stuff like that, and want to better my life basically at this point. So.
All right. In determining the appropriate sentence in your case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the report and recommendation of the probation department, as well as what's been said on the record here this morning. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, vindication for the law, and the protection of society. Mr. Carter's 27 years old, has pled guilty in this case to attempted identity theft. And there is an agreement in this case that there would be no upfront jail, which is consistent with the guideline recommendation in this case. I do think that the recommendation of probation is appropriate given the circumstances. We've addressed, I think, the requirement that Mr. Carter enroll or continue in education or vocational training. If Mr. Carter, you can provide verification of your high school graduation and your degree to your probation officer, then that obviously won't be necessary. So it will be the sentence of the court that you serve a period of probation for 2 years, subject to the following conditions. You must not use or possess alcoholic beverages or other intoxicants. You must not enter bars or other places where the primary purpose is to serve alcoholic beverages for drinking on site, unless the field agent has first given you written permission for your employment at a specific location. You must comply with the requirements of drug and alcohol testing as directed by your field agent. You must not attempt to submit any fraudulent or adulterated samples for testing. You must not hinder, obstruct, tamper, or otherwise interfere with testing procedures. And you must present proper identification at the time of testing. You must not use or possess any controlled substances or drug paraphernalia unless prescribed to you by a licensed physician or be with anyone that you know to possess those items. You must complete a substance abuse assessment if you are referred by your field agent. You must enroll in or continue in educational or vocational training as directed by your field agent. You must not use any object as a weapon. You must not own, use, or have under your control or area of control any type or imitation of a weapon. You must not be in the company of anyone that you know to possess those items. You must submit to a search of your person and property, including but not limited to your vehicle, residence, and computer, without need of a warrant if the field agent has reasonable cause to believe they have items which violate the terms of your probation. You must pay restitution in the amount of $8,000. You must execute a wage assignment to pay restitution if you are employed and miss 2 regularly scheduled payments. You must pay a crime victims assessment of $130. You must pay a supervision fee of $30 per month. That would be increased to $60 per month if electronic monitoring is required, which is not required at this point. You must pay $750 court costs and a $68 state cost. You do have the right, Mr. Carter, the ability to request an appeal of your sentence. We're going to send to you 3 copies of a notice of right to appellate review and request for appointment of attorney form. When you get that form, Mr. Carter, you need to sign one of them. There's 3 copies of it. You need to sign one and send that back to the court. That just indicates that you got your copies of those forms. If you want to appeal your sentence, you would need to fill out the remaining portion of that form and mail it to the address listed in the form within 42 days. Do you understand that?
Yes, sir.
All right, Ms. Holly, when do you need Mr. Carter to report?
Tuesday. I know he lives in Lansing, so he can report between 2 and 4.
I mean,
Okay.
like I was trying to explain to her, I usually have to work from around 8 a.m. to 6 p.m. So I'm, kind of trying to figure that out now when I'm going to be able to make it down there.
All right, well, you're going to need to make it down there because you have to report in person at least the first time because there are documents that you need to sign. So you need to report in person on Tuesday.
All right, I guess, yeah, all right. These people is crazy.
right, you can go ahead and log out then, Mr. Carter.
Thank you, Judge.
Thank you, Your Honor. That's all I have with you.
Thank you, Mr. Glazer. All right, we are back on the record in file 24-22031-FH and 24-22029-FH. Ms. Underwood, would you like to place your appearance on the record?
Ron, I'll do it for Mr. Skinner this morning, Your Honor. Thank you.
All right, and do you know how Mr. Skinner would like to proceed today?
Your Honor, at this time, we would ask the court to enter a not guilty plea on Mr. Skinner's behalf. Your Honor, this is a show cause from only Wednesday. Mr. Skinner, when he was told there was a warrant, planned on turning himself into the court yesterday morning. Unfortunately, of course, court wasn't open, and Mr. Skinner got stopped last night, and we're here this morning, Your Honor. I think this can all be worked out. I'm hoping that we can set it for Wednesday, and I'm hoping the court would consider a PR bond on Mr. Skinner's behalf, Your Honor. I do have a up-to-date address for Mr. Skinner. I don't believe Mr. Skinner has any history of failing to appear for court, Your Honor. We would hope the court would give Mr. Skinner a PR bond and set this matter for Wednesday. And I will, if the court wants me to, give Mr. Skinner's address, or I would be happy to do that in a breakout with his probation officer.
All right, so I will enter a not guilty plea and set this for Wednesday morning, June 25th at 8:15 a.m. I'm not going to modify the bond in these cases. Mr. Skinner has a history of failing to appear at least twice. He failed to appear at arraignment. He failed to appear at sentencing. He had another show cause for failing to test. And so I don't think that a PR bond is appropriate in this case.
Thank you, Your Honor.
Thank you. Mr. Skinner, you can let the officer with you know that you're done with court for today.
Yes, sir. You have a good day.
I believe that's my docket this morning, Your Honor. Thank you. Have a good
Thank you,
weekend,
Ms. Underwood.
everyone.
All right, Mr. Grable, are you ready to proceed with Mr. Sepulveda?
We are, Your Honor. Thank you.
Okay, this is file 23-21463-FC, People versus Ricardo Sepulveda. We are here today for sentencing in this case, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Hoffman.
Thank you, Your Honor. Good morning. Benita Hoffman, Assistant Attorney General on behalf of the people. For the record, my bar number is P48738.
Good morning, Your Honor. Attorney Scott Grable, P53310 for Mr. Sepulveda. Myself and Mr. Sepulveda are here by Zoom, and we waive, obviously, appearing in person. Thank you, Your Honor.
All right, and sir, you are Ricardo Sepulveda, correct?
Yes, Your Honor.
Mr. Sepulveda, this is a sentencing in a felony case. As a result of that, you do have a right to be present in person here in the courtroom for the sentencing hearing. I would only continue by video conference if you are willing to waive your right to be here in person and continue by Zoom. Are you willing to do that at this point?
Yes, Your Honor. I'm willing to waive my in-person right to be at court.
Okay. Have you had an opportunity to read and review your pre-sentence report?
I have, Your Honor.
Have you had an opportunity to discuss that report with Mr. Grable?
Yes, we just a few minutes ago discussed it.
Are you satisfied with Mr. Grable and the advice that he's given you?
Yes, we went over a few things on the report that we feel needs to be edited or omitted.
Okay. Do you wish to explain or challenge the accuracy or the relevancy of any of the information that is in your pre-sentence report?
Yes, we definitely would challenge some of the information, the accuracy of the information in there. I would defer to Mr. Grable to explain it.
Okay, Mr. Grable.
I would, Your Honor. First of all, Your Honor, I just want to make sure we sent to your staff and we're filing a hard copy with the clerk's office, a sentencing memorandum. We've also given it to Ms. Hoffman from the Attorney General's office. For the record, I just want to make sure the court is in possession of that. And we do have a hard copy coming by mail as well. And I think Ms. Hoffman should be in possession of that as well.
I do have a copy.
Go ahead, Ms. Hoffman.
Your Honor, I do have a copy of the sentencing memorandum that was filed by the defendant's attorney.
Okay, and I have received and reviewed that as well.
Okay. Your Honor, I'll go into the report. There's just a few changes, Your Honor. On page 1 on the body, it says count 1, homicide, murder, first to be conspiracy. Just for clarity, Your Honor, I think it might be important just to change that to count 2, because obviously count 1 of the first degree premeditated, as the court is aware, obviously Mr. Sepulveda was found not guilty. I just think it might add some clarity because it is incorrect. It was count 2, not count 1. Not a big deal, but I still think it should be accurate on that point, just so Department of Corrections doesn't get confused. That would be my first change.
Okay, Ms. Hoffman, do you have any issue with that?
I do not, Your Honor.
Okay, so that should be modified to reflect count 2 as the homicide conspiracy charge.
Okay. On page 3 of the report, Your Honor, it indicates, again, count 1, homicide, top of page 3 of the report. It indicates, the charge is correct, conspiracy, but again, it references count 1 again for the same reasons I've illustrated. That should be count 2 on page 3. Again, same reason.
Any issue there, Ms. Hoffman?
No, Your Honor.
And Your Honor, I'll probably reserve argument on it, but I'm going to ask on that paragraph on the top of page 3, I would indicate that, and again, I'll make the argument when the court is ready. It's outlined in my memorandum that Department of Corrections should be aware that Mr. Sepulveda is eligible for parole after the appropriate time period, but I could be more specific, or I can do it now based on the sentencing memorandum. I don't think there's any dispute, but we can come back to that later, Your Honor. I can make some other minor changes and proceed whatever the court's pleasure is.
Okay, so I'm sorry, going back to the labeling of the counts, it looks like they will all need to be renumbered.
That would be correct. I apologize, Your Honor. Just sequentially to respect, right. I would agree, and I apologize. That would be, I guess, instead of 2, 3, 4, 5, it should be obviously 3, 4, 5, and 6, or 2, 3, 4, 5, and 6 on those numbers sequentially. Right. You're correct, Your Honor. I apologize. They should be altered for the same reason, just for the housekeeping purpose to make it accurate.
Yeah, so he was convicted on counts 2 through 6 and found not guilty on count 1. All right, I'll save the parole issue for I think later. I don't think that's an issue with the PSI as much as it is what the sentence should be. So
that's correct, Your Honor. For the record, too, and I won't go into it, I did get a chance to speak to probation. I don't know if he's here by Zoom, Mr. Stevens. He agrees with me on the parole issue, and he can illustrate that himself. So he's not opposing that change. But I'll deal with that momentarily if he's here. He's consulted with Jackie Wise, the Lenawee County prosecutor, but he can verify what I'm saying. He agrees with me that this is parole eligible, but I wanted to mention that as well, but I'll ducktail back to that at the appropriate time with the court's permission.
All right, did you have any other additions, corrections, or deletions in the pre-sentence report?
I do. On the evaluation and plan, Your Honor, at the top, again, it indicates count 2 homicide, murder, first degree. Again, for clarity, I think it should indicate conspiracy to commit homicide. I think it's a little confusing. It looks like it has the correct count number, count 2, but it just indicates homicide, murder, first degree. I think it should indicate conspiracy to commit homicide, first degree, premeditated. Again, I think that would add the appropriate clarity to it. Again, I don't think it changes any of the dynamics, but I think it would be more accurate.
All right, Ms. Hoffman, any issue with that correction?
No.
Okay, so we will make that correction as well.
On page 2, Your Honor, under description of the offense, the paragraph that starts on 12098, Laura Lozana's former boyfriend, Thomas, and then it goes on. My understanding, obviously, I think that is in one of the incident reports that mentions that statement, but I understand, obviously, the court's aware, or maybe I have to refresh their memory. Thomas did not testify at trial. I think he was a subpoenaed witness, but I think they could not locate him. So for that reason, although I think there was some testimony that was outlined in the incident report, the fact that he was a no-show for trial, I would ask that that whole paragraph and represented to Thomas should be deleted. But again, there was an incident report that I think mentioned that as a summary. But again, I think he avoided service. I think the court, and Ms. Hoffman will make sure I'm saying this accurately, I think there was a bench warrant issue, but maybe I'm confusing that with a different witness. If I am, I'm going to ask her to correct me because I don't want to mislead the court if I'm wrong.
All right.
So
Go ahead.
if I could respond, Your Honor, with respect to the missing witness, that the bench warrant was issued for, that witness was Billy Morgan, or William Morgan, which is his legal name. With respect to the comment made by Tommy Thomas, there were statements that were presented during the trial regarding Tommy Thomas. I think the correct way to handle this, if there is an objection, is that although Mr. Thomas did not testify at trial, an incident report says that he said this.
I would agree with Ms. Hoffman that I don't think simply the fact that he didn't testify at trial means that it can't be in the pre-sentence investigation report, because that report can include things other than the trial record. And so I think that the way that Ms. Hoffman has couched that phrasing would be appropriate, to simply indicate that although he did not testify at trial, there is an incident report which says the following. So I would make that correction.
Very good, Your Honor. One thing too, and I know we're going to address it, same page right under recommendation narrative, and indicates on count 2, the defendant served life without the possibility of parole. I just wanted to highlight it to the court's attention that obviously I'm going to object to that, but the court wants, if the court makes a ruling that may alter that, I'm going to ask they change that, and just to highlight it to the court for later analysis once we're done going through these changes. On the top of page 2, I just didn't want to forget, just to make aware that the court may change that or may not, but I'm saying I want it part of the analysis of changing that, where it says it's defendant served life without the possibility of parole. That should be addressed when the court does address it. I just didn't want to forget that, because obviously.
Okay.
Thank you, Your Honor. On the same page on 1/16/2002, it says Brahim Dahar, and then it goes on. This may be small. I think Mr. Dahar's testimony indicated during his then that they said there was some statement. He stayed in the summer of '99 while at Laura Lozano's house. Again, this may be quibbling, but I think he testified during trial they were at his house. Again, I don't think it changes anything dramatic, but to be accurate, I think he indicated it was his house. Again, I don't think it changes the dynamic, but factually, I think that's what the trial record indicated under oath.
Ms. Hoffman?
Could you give that to me again, please?
Yeah, I'll clean it up. I think the statement indicates that there was some discussion about this murder. I think they said the meeting took place at Laura Lozano's house. I think Mr. Dihar indicated the meeting took place at his house. I agree that may not be salient to change anything, but I think that's what his trial testimony said. I want it to be accurate. I don't think it's going to change the nefarious nature of the conversation, but it's just for accuracy. I think it
So
was
it's,
a trial testimony.
So the issue is that the PSI says that the conversation occurred at Laura Lozano's house, and Mr. Grable says that the testimony was that the conversation occurred at Mr. Dahar's house.
That's it. I understand that's not an earth-shaking fact from a relevant standpoint, but Mr. Sepulveda brought that to my attention. I just didn't want to ignore it. Again, I don't think it's going to change the context of anything other than where the meeting.
Oh, okay, Ms. Hoffman, do you have any input on that issue?
sure. First, the conversation regarding the plan to commit the murder began in Ohio and continued to Laura Lozano's house, as did the
Okay,
plan.
I'm sorry to interrupt, but you're not talking about the same conversation. This is a conversation that Mr. Dahar testified about, where Mr. Sepulveda told him that this had happened, not planning.
Oh, so I think that he actually testified that they were at Laura Lozano's home when he admitted he had gone to Laura Lozano's home and they were in the basement at the home and they were smoking marijuana. I understand the confusion because the incident report says that it happened at Mr. Dahar's house, but I thought the testimony at trial was that it was at Ms. Lozano's house. I think it's either. I think the best way to put it is that it either occurred at Laura Lozano's or it occurred at Brahim Dahar's.
All right, I don't have a recollection of what the testimony was on that point, and I don't think it's a relevant point to anything that would have an impact on what his sentence would be or what would happen in the future regarding his sentence. So I would just delete the phrase "while at Laura Lozano's house" and just leave it that there was a conversation.
Fair enough, Your Honor. The last sentence in that paragraph indicates he indicated they decapitated him, excuse me. Brahim Dahar indicated that Michael and Ricardo had told him about the murder separately while they were in prison. For the record, again, small issue. Mr. Dahar and Mr. Sepulveda never served in prison together at the same facility, so I don't know if there were any reports indicated that they were not in prison together at the same time. Again, not a big issue, but Mr. Sepulveda brought it to my attention, so I'm bringing it to the court's attention. I don't think it's accurate.
Hey, if I could, Your Honor, it was Yusuf Dahar that served with Mr. Sepulveda in prison, not Brahim. Yusuf
All right,
was
so-
Brahim's brother. I'm sorry, Your Honor.
And I'm almost finished, Your Honor, after this. So.
I apologize, my memory's failing me. Yusuf Dahar did not testify, right?
Yes,
Yes, Your Honor.
I
That's
believe he's deceased.
I'm sorry.
I believe he's deceased.
Yeah.
Yes.
Okay, so then I would just strike "and Ricardo" from that statement.
Thank you, Your Honor. With the court's permission, I'll move along quickly to wrap this up. On 420.05, there's a paragraph about a call that referenced, I think, a 911 call, which there is an incident report that indicates that but Laura Lozano testified, obviously, at trial, and I think it would be inconsistent with what was in the incident report I think there was some impeachment attempt, but she never acknowledged that. I think, or it was Misty Reynolds who testified. Pardon me, Your Honor. I apologize. I don't think she confirmed she made the 911 call or anything that would indicate the context of that paragraph. So I'm going to ask that paragraph be deleted because although there was an incident report, obviously I don't think she was impeached at trial. She denied having memory or her memory wasn't refreshed. So I'm just going to ask the court to delete that whole paragraph in reference to this 911 call.
Your Honor, it was Kathy Furl that made the 911 call.
No, it wasn't. It was Misty
Okay,
Reynolds.
don't let Rick, don't interrupt. It's let the judge rule on it, please. Obviously,
If I,
go ahead.
if I may interrupt, if you look at the incident report, there were a couple of calls to 911.
Well, this says Misty Reynolds, obviously, in the statement. So, and whatever the court rules is fine. I just wanted to bring, obviously, it sounds like Ms. Hoffman is not saying it was Misty Reynolds, or that's what the PSI says.
All right, there does seem to be at least some error in that paragraph, and I think, again, it only would have tangential relevance.
I agree.
I'm just going to strike the entire paragraph and leave that paragraph out.
Thank you. I'll try to wrap this up. On page 3, Your Honor, third paragraph down that starts on 12/2/16, there's mention of a family wake. And I remember the testimony at trial. They heard Michael state that he witnessed Ricardo kill and dismember a man. I think the testimony at trial from Michael was, or I think there was actually another witness, not from Michael. And the name escapes me, but I think the testimony was, your words are words to the effect, you're going to go down for murder, MF. I'm not going to say what the court knows what the word MF is. And then I think they said Mr. Sepulveda was silent and didn't respond. I think that's probably more of an accurate rendition of what the testimony was at trial than this statement that was contained in the report. So I don't think that characterization in the report that I referenced is consistent with what was offered at trial by one of the witnesses at the wake. That's it.
I agree with Mr. Grable, Your Honor.
Okay. So that paragraph should end of that paragraph should read, they heard Michael state that Ricardo was going down for murder, which would be consistent with the testimony at trial.
Thank you, Your Honor. One more point I guess on page 3 in the body, and I'm going to skip down, I don't know how many lines, toward not the last paragraph, but the body of the polygraph where it's Toledo, Ohio area, down about 8 or 9 lines down. It starts at that point, Ricardo began to stomp the victim's head with his foot until he was deceased. I'm not sure, obviously, the client was acquitted of the first-degree premeditated murder. I don't know if it makes, at that point, he began to stomp the victim's head with his foot until he was deceased. I'm not sure. I would argue that the not guilty on the premeditated would make that statement, I guess, not supporting the record of the not guilty. So I would ask the court to delete at that point, etc. That one sentence. I would ask the court to delete that based on the not guilty of count 1.
Ms. Hoffman.
If we're going to change that statement at all, it should say that the defendant stomped his head until it was smashed in, while his brother hit the victim in the head with the butt of a pistol, and that he died thereafter.
I would defer to the court. I would just indicate the statement should be deleted, but I'll let the court rule on that. And that's my last change to the report, Your Honor.
All right, I believe that Ms. Hoffman's statement was an accurate reflection of what the testimony was at trial. I would preface the statement that that Michael testified that at that point. And I'm sorry, what was the remainder of?
So as the defendant was on on the victim's head, his brother, Michael Sepulveda, was pistol whipping him, and thereafter the victim died.
All right, again, with the preface that that is what Michael testified to at trial, that is what I would make that statement.
Thank you.
Thank you, Your Honor. And I
All right.
believe it's accurately scored as well, so I'm not challenging any of the scoring calculations on this as well, Your Honor.
All right, Mr. Grable, did the pre-sentence report disclose any prior convictions in which there exist any known constitutional defects?
I don't believe it did, Your Honor, other than the issue of that we're going to address on the parolability of count 2. Other than that, that issue I do believe would be a constitutional violation, but nothing besides that issue that we're going to address. I believe it's acceptable.
All right, and you indicated that you have no issue with the scoring of the guidelines, is that correct?
I don't have an issue, Your Honor. I believe, and to the relevant offenses, I believe it's accurately scored with the guidelines that were in place at the time the offense was committed, based on the time established at trial. I concur with that, yes.
Ms. Hoffman, did you have any issue with the guideline scoring?
I do not, Your Honor.
All right, and that was on the assault with intent to maim 48 to 80 months.
I believe that's correct, Your Honor.
Yes.
Okay, so I have read your brief, Mr. Grable, with respect to the guideline scoring. I will give you a moment at this point if you want to say anything in addition to what you've submitted in writing.
I'll be brief, Your Honor. I'm not going to be circuitous. Obviously, I think the memorandum that we outlined illustrates that I think this is a absolutely black and white issue. I did want to add, Your Honor, I did bring this to probation, obviously Circuit Court probation's attention. I believe it was Mr. Stevens. I'm looking for his name in the report. I know it was signed by the supervisor. If I miscite who authored the report, he did contact me a couple days ago, and I don't know if he's in the Zoom meeting room. I'm hoping he is. So he'll confirm what I'm saying. He agreed with me that this is a parolable offense. He indicated that he consulted with Jackie Wise, who I understand is not the prosecutor in this case. Of course, she is the Lenawee County prosecuting attorney. He will confirm that she agreed as well. This is a parolable offense. Obviously, the law in place, Your Honor, in 1997, based on the rationale and analysis in my brief, makes this a parolable offense that, in my opinion, should be reflected in the judgment of sentence. Obviously, the law changed on this, I believe, in 2014. Obviously, the court's aware of ex post facto that obviously the punishment that was applicable at the time in 97 would make this a parole eligible offense, and you can't apply retroactively the 2014 modification to the statute. So clearly this is parolable. I think the case law is clear. I don't think the case, I think Ms. Hoffman gave me a case that was a 1986 case. It doesn't apply or change the rationale here. My position, in my opinion, is crystal clear and correct. I'm sure the court, knowing I know the court's, how the court handles these procedurally, I'm sure the court did a copious review of this. So I'll defer to the court, but I do believe everything in the report that indicates this is not parolable should be modified to parolable, and it should be included in the judgment of sentence. I believe it would be parolable after 15 years. Obviously, it still has to go through the parole board, but it is parolable in my opinion. I think it's absolutely unequivocally clear based on the case law I cited in my memorandum, which I incorporate. Thank you.
Ms. Hoffman.
Your Honor, turning first to the issue of parolability, the statute does specify that the defendant is to be sentenced to life in prison. It does not say non-parolable life in prison. So I agree with him with opposing counsel regarding that particular issue. However, that does not automatically mean that Mr. Sepulveda is going to be eligible for parole or that he's going to receive a shot at parole in 15 years. Michigan Department of Corrections guidance on this says that the person can be considered, but at the time in 1997, the policy of the Michigan Department of Corrections was that life meant life. And part of the reason for that is because a first-degree homicide conviction or conspiracy to commit first-degree homicide, by simple logic, should carry a harsher penalty than a second-degree murder charge, which also carries life for any term of years. And so for that reason, I believe that the pre-sentence investigation report need not reflect that he's eligible for parole in 15 years, because once he gets inside the Department of Corrections, it is up to the Department of Corrections. There is federal case law on this issue in terms of whether or not being granted parole or being denied parole such that the person winds up serving life without parole is an ex post facto violation. And the Sixth Circuit, as well as the Michigan Supreme Court, have both concluded that it is not. If opposing counsel had served me his sentencing brief sooner, I could have gotten a response put together. I can find the cases for the court if the court would like that. One of them is People versus Neely, and then the other one is People versus Fernandez. And then the third case that I wanted to bring to the court's attention was the, hold on, I will find it. Give me 1 second. I had it open. The one is People versus William Edward Neely, and it is case number 165185, which was issued July 8th of 2024.
So
And
it's
then
not reported?
it is reported. All Michigan Supreme Court cases are reported,
Well,
Your Honor.
can I have the site?
I don't think it's been reduced to a site yet, Your Honor, because of the way they publish the volumes. But if you'll give me 1 moment. Yeah, I only have, Your Honor, I apologize. I only have the case number, which is number 165185, and it was issued July 8th of 2024 by the Michigan Supreme Court.
And I'm sorry, what were the other cases that you mentioned?
People versus Neely was one, and the other one was other one. Foster Bay versus Sampson. but it's an unpublished opinion, Your Honor.
So I guess, let me just see if I can understand clearly, Ms. Hoffman, do you agree or disagree that the court cannot sentence to life without parole?
I believe that that is correct. The court can sentence to life and make a recommendation that he not receive parole, but I don't think that the court can issue a sentence of life without parole. And the distinction is that if the court were to recommend no parole, that would be a recommendation that the Department of Corrections Parole Board would receive, and they have the authority to determine whether or not he's eligible for parole, or will receive, I should say, whether or not he should receive parole at 15 years. So I'm asking the court to sentence him to life and to recommend that he not be granted parole.
I would object to that, Your Honor. I would let the parole board decide. I've never seen a court put in there that you're recommending against parole. I've never heard that in the judgment of sentence. Again, to be respectful, obviously, once I determined this became an issue, I served the sentencing memorandum. I have not reviewed the cases, obviously, that Ms. Hoffman made. I can agree with her. She needed additional time. I certainly wouldn't have posed an adjournment for the sentencing today so she could submit those citations. Obviously, Mr. Sepulveda is in jail. He's not going anywhere. But either way, Your Honor, I don't think any of those cases are going to stand for the proposition. And again, I haven't read them, but it doesn't sound like they stand for the proposition that the court can now function as the parole board. I'm recommending against parole. I don't think so. I don't think it's respectfully, I think the court has wide powers, but I don't believe the court should now put their hat on as the parole board to recommend against parole. I've never seen that in my life. I think it should indicate that he has the possibility of parole, and I think that's what the judgment of sentence should reflect, and let the parole board make the determination, not the circuit court. And I say that with respect to this court. I understand they have equitable powers and some plenary powers, but I don't think that language would all be appropriate in the judgment of sentence. I don't believe any case law or anything supports that. But obviously, I'll defer to the court, but I think I'm correct on that issue. Thank you.
Your Honor, if the court is inclined to follow Mr. Grable's analysis, then I would recommend that the court sentence the defendant to life in prison and not say anything about its eligibility for parole, and let the Department of Corrections follow its internal procedures and statutory authority when determining whether or not he's eligible for parole, because there is a distinction between being eligible and being granted. And MDOC has had in the past a policy that did not allow parole for a first-degree homicide offense or for conspiracy to commit first-degree homicide. And it was upheld. It wasn't considered an ex post facto violation of the law for that to occur, because the discretion to grant parole is completely within the discretion to grant or deny parole rests with the parole board, although the court can be consulted with respect to whether or not parole should be granted. That was the procedure back in 1997. So to simplify, I'm just asking that the court sentence him to life in prison, and perhaps just not say anything at all about parole.
I didn't mean to cut Ms. Hoffman off. Were you finished? I didn't want to cut off your thought.
As to the parole issue, yes.
Okay, that's fine. Judge, the only language I put in there in my memorandum, I think it speaks succinctly.
Mr. Grable, I apologize for interrupting, but I've read the memorandum, and so the continued back and forth at this point, unless you have something new, is not is becoming cumulative. So
okay, fair enough. Your Honor. I think it should say is the life set that.
Okay, thank you, Mr. Grable. Thank you. I know what you think it should say.
All right, well, I won't say anything further. I think the court certainly is aware of the argument. Thank you, Your Honor.
What is clear to the court is that the law as it existed in 1997 is the law that the court has to apply in sentencing today. At that time, as Mr. Grable has pointed out in his memorandum, the law did not have a provision for sentencing a person to a life sentence without parole. And so the court does not have the power to sentence Mr. Sepulveda to a life sentence without parole. And that is how the court is going to operate today. I'm not going to get into what the policies of the Michigan Department of Corrections were in 1997 because it's not my job to make or apply those policies. It's the job of the Michigan Department of Corrections to apply those policies. So that's how I intend to treat this matter. Did you have other issues you needed to address, Mr. Gray?
No, Your Honor, I just want to make sure with the court's guidance, what areas of the pre-sentence investigation report that's modified to reflect the court's ruling. And I'll let the court put on the record what they want to change. I've noted a few places that I think would hopefully, and I'll let the court decide, should effectuate what the court just said.
To the extent that the report has any indication of the sentence being without parole, I would omit any such references.
And I think, obviously, I've highlighted the areas, Your Honor. I'm not going to repeat them as long as it's notated in the final version. I just want to make sure that doesn't add any. I think you were crystal clear. I just want to make sure the report doesn't confuse Department of Corrections because we may potentially be revisiting the issue in 15 years. And I think as long as the court makes the notations, I'm certainly satisfied with that, Your Honor. I think the ruling was, you made it clear. Other than that, Your Honor, I won't take up the court's time on this issue. I think it made its ruling.
All right, Ms. Hoffman, did you have any additions, corrections, or deletions? I don't believe I ever asked you that question.
No, Your Honor, I don't.
All right, before the court passes sentence, then, Mr. Grable, is there anything you want to say on behalf of Mr. Sepulveda?
Well, Your Honor, the court heard lengthy testimony. So as far as allocution, I'm simply going to ask the court, other than the modification for the parole, to follow the recommendation, Your Honor. I don't think there's much that can be said that isn't said in the pre-sentence report. So I'm just going to ask the court to follow the recommendation, Your Honor, obviously, other than the parole modification that the court has opined on. Other than that, Your Honor, I'm not going to say anything else. Thank you.
Mr. Sepulveda, is there anything that you would like to say on your own behalf before the court passes sentence?
No, Your Honor.
Your Honor,
Ms.
I'm sorry. Do we have a concession that there is a prior felony conviction for the purposes of the habitual offender supplement? It's referenced in the report. Opposing counsel didn't object to it, but I want to make sure that that's established.
I believe it's established, yes.
Thank you. I do wish to allocute if the court would allow.
Go ahead.
Thank you. Your Honor, this was a horribly gruesome crime that was related to drug trafficking in Southeast Michigan and Northwest Ohio. In all of the things that the court has to consider, one of the things that is significant is that this victim was kidnapped from Ohio and brought to Michigan, where he was brutally murdered and then dismembered. The defendant's conduct was clever. It was calculated. It was goal-oriented. It was plainly premeditated. He scattered the evidence along with his brother in a way that made it impossible for law enforcement to identify who the victim was, and which successfully kept his involvement in the crime hidden for several decades. the savagery of the crime is just beyond explanation. To imagine being kidnapped, hit over the head, stabbed, taken into a field, stomped out, hit with a pistol, and left for dead. And then to have them come back and say, oh no, that wasn't good enough. We have to go back. And then cut off his head and cut off both of his hands so that no one could identify him. And to make matters worse, they further desecrated the body by pouring some sort of a solvent, bleach, possibly Drano, over the victim's body so that no trace evidence could be found, so that no identification of this victim was possible. And here we are, several decades after the offense. We still don't know who the victim is. We don't know the true identity of the victim. Somewhere, whether they're good law-abiding people or not, there is a family that needs to know who this victim was so that they can know for sure what happened. And perhaps the worst part about the crime, in addition to the severity of it, the brutality of it, is the unlawful motive it served to achieve, and that is to avoid paying a drug debt to a cartel. I respectfully submit to the court that in addition to the sentence being imposed for the defendant for life in prison for the first offense, that the court should depart from the sentencing guidelines on the lesser offenses and sentence the defendant to 10 to 15 years on the minimum sentence. Because of the severity of the crime, because of the brutality with which the crime was committed, because it was organized, premeditated, related to cartel involvement, because it was beyond what was necessary to kill the person. The state firmly believes that the defendant should go to prison for the rest of his life. The state also firmly hopes that the Department of Corrections never allows Mr. Sepulveda to be granted parole and never allows Mr. Sepulveda to rejoin society. He's too dangerous. He's too dangerous, and his connections in the outside world in civilized society are connected to the uncivilized portions of society, those who resort to this kind of violence to continue to profit, to protect their profit margin from the trafficking of cocaine and fentanyl and heroin and marijuana. For all those reasons, we ask the court to sentence him to life in prison for the conspiracy to commit murder. And we also ask that the court depart from the sentencing guidelines for the objective and verifiable reasons that are not covered by the sentencing guidelines and sentence him to 10 to 15 years on each of the lesser offenses. Thank you.
In determining the appropriate sentence in this case, the court has considered the seriousness of the offenses, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the report and recommendation of the probation department, as well as what's been said on the record today. The criterion reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to their commission, deterrence against repetition by you and by others, vindication for the law, and the protection of society. Mr. Sepulveda is 53 years old and has been convicted of conspiracy to commit homicide, first-degree murder, assault with intent to maim, 2 counts, and tampering with evidence, 2 counts. Court obviously sat through the trial and heard all of the testimony in this case. And I would agree with Ms. Hoffman that this was a particularly gruesome offense, the likes of which I certainly have never seen before. in my time on the bench. And it resulted in the death of a person who is still unknown, at least to us. And somewhere in this world, there are people who have grieved the loss of a son or a brother or a husband or whatever relationships that this person has when he was murdered. It also occurred in the context of a drug dealing operation. And so there was, although not charged in this case, testimony of significant other criminal activity that was going on which it appeared from the evidence to be primarily orchestrated by Mr. Sepulveda. In looking at the guideline scoring on the assault with intent to maim charge, the guidelines ended up at 48 to 80 months. I would note that the offense variables were scored at 115 in this case. And when we look at the severity levels as they go up, we're well beyond the top, the minimum score for the top level of the offense variables. And I think that speaks to, again, the gruesome nature of the crime and what occurred here. With respect to the conspiracy to commit homicide case, I've stated it already, but the law that applied in 1997 is the law that applies to this case. In 1997, the law had no provision for sentencing a person to life without possibility of parole. It simply said that a person guilty of this particular crime would be sentenced to life in prison. And so that will be the sentence of the court on count one, that Mr. Sepulveda be sentenced to the Michigan Department of Corrections for life with credit for 878 days served. There is in that file, $130 crime victims' rights fee and $340 state cost. With respect to the remaining counts, the 2 counts of assault with intent to maim, which include a habitual offender, as well as the 2 counts of tampering with evidence. I do believe in this case that the guidelines do not adequately address the particular circumstances of Mr. Sepulveda, and they do not adequately address the circumstances of this crime, particularly the gruesome nature of not simply murdering a person, but in the context of doing that, also kidnapping that person, taking them across state lines to try to conceal, finish the job, essentially, try to conceal the body, and then come back later and cut the head and the hands off of a person to conceal that person's identity so that they would never be known. And again, to this date, that identity is not known. I think that goes far beyond and is more heinous, more savage, more gruesome than even the vast majority of the murder cases that we have to deal with. And so I do think that a more proportionate sentence on those counts would be 10 to 15 years rather than what the guidelines would call for. And so that would be the sentence of the court with respect to counts 3, 4, 5, and 6. All would be 10 to 15 years with credit for 878 days served. Those sentences are all concurrent with each other. Mr. Sepulveda, you do have the ability to request an appeal of your sentence. We will send to you 3 copies of a notice of right to appellate review and request for appointment of attorney form. When you get those forms, you'll need to sign 1 copy and return that to the court. It just indicates that you received your copies of those forms. If you want to appeal your sentence, you would need to fill out the remaining portion of that form and mail it to the address listed in the form within 42 days. Do you understand that, sir?
Yes, Your Honor. I would ask the court in the meantime to recognize that I'm going to proceed pro se until such a time as I can fill those forms out. Following today's hearing, I mean.
All right. That is fine. If it's your wish to represent yourself at this point until you get those forms, that is your right.
Your Honor, could I also ask the court, I don't know if this is the proper time or not, to provide me with a copy of the trial transcripts and any of the evidence exhibits?
I think those might have been ordered, but I will check, and if they have not, we will enter an order for those to be prepared.
Thank you, Your Honor.
All right. With that, then you can let the officer that's with you know that you are done with court for today.
Oh, one last thing, Your Honor. We haven't you haven't talked about court costs or anything like that?
I think he did. I think the
Oh,
court
did you?
indicated there was 130, 340. Obviously, for the record, the client's indigent, Your Honor, but obviously the court's ruled on that, but I think I'm not going to address that other than these indigents.
Okay, so I guess just for, could you please repeat what my total costs are or whatever, Your Honor, just so I have a clear understanding?
The crime victims assessment is $130, and there's a state cost of $340.
And where do I pay those to, or is there any possibility of getting?
I can advise you on that after.
Is there a possibility of getting any of those costs waived or reduced?
So I've waived all of the costs that can be waived and assessed the ones that I'm required to assess.
Okay, understood. Thank you, Your Honor.
All right. So if that's all, then you can let the officer that's with you know that you are finished with court.
All right.
Thank
Thank you,
you.
Your Honor. Thank you, Mr. Grable.
I appreciate it. Thank you, Judge. Thank you, Ms.
Thank you, Your Honor.
Thank you, Your Honor.
I'm going to log off, Your Honor. I just wanted to make sure the court didn't need me for anything else. Log off.
Yeah, we're all set. Thank you, Mr. Grable.
Thank you for your time as always, Your Honor.
Yes, this is Judge Saber. Oh, he is. Okay, thank you very much. Mr. Mawad, do you need to speak to Mr. Higgins?
No, Judge, I did speak to him Sunday in a jail conference. Thank you.
L 24-21964-FC, People versus Matthew Virgil Higgins Jr. We are here today for sentencing in this case, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. Arnold for the people.
Allison Arnold for the people.
Elias Muwad appearing on behalf of Mr. Higgins.
And sir, you are Matthew Virgil Higgins Jr.
Yes, that's correct.
Mr. Higgins, have you had an opportunity to read and review your pre-sentence report?
Yes, I've had the opportunity to review it with my.
Did you have an opportunity to discuss that report with Mr. Mawad?
Yes, Your Honor.
Are you satisfied with Mr. Mawad and the advice that he's given?
Yes, Your Honor.
Do you wish to explain or challenge the accuracy or relevancy of any information that is in your pre-sentence report?
No, Your Honor.
Ms. Arnold, do the people have any additions, corrections, or deletions?
We do, Your Honor. Regarding the children's ages, I believe that Matthew Higgins III is 22 years old rather than 18 years old. And on the pre-sentence investigation, the Snapchat conversations were covered from phones, devices. I had a chance to speak with the victim, Madison Higgins, and she stated that she did not send those Snapchat conversations to the individuals who appear to be her friends. She said she didn't even know all of those girls. She said her mother had her phone during that time. I spoke with Leanne Higgins, and Leanne Higgins said she didn't send the Snapchat conversations. She suggested that perhaps Matthew Higgins himself did it. We're very confused by that. So I would ask that Snapchat conversations were covered from phones, devices, that whole section be deleted from the pre-sentence investigation, because there's some serious doubt about who sent those messages and for what purpose.
Okay. Mr. Mawad, do you have any, well, first let me ask you about the age of Matthew Higgins III. Is it accurate that he is 22 years old?
Yes, but I want to confirm with Matt. Matt, is that correct?
That's correct. Yes, he's 23.
All right.
All right. And then, so Ms. Arnold, we're talking about page 3 of the pre-sentence investigation. And if I'm understanding you correctly, are we deleting everything beginning with several thousand text messages through the end of that section?
No, I think just from the Snapchat conversations down.
Oh, okay.
To where it says consecutive sentencing.
Okay, so yeah, there's in all caps, it says Snapchat conversations were covered, so just that portion.
Correct.
Okay. And Mr. Mawad, do you have any issue with deleting that portion of the pre-sentence investigation?
I do not, Judge. Thank you.
Okay, so that section, everything from the all caps Snapchat conversations were covered from phone/devices through the end of that section until we get to consecutive sentences will be deleted.
Judge, can I make a really quick comment? We had a problem on our last hearing where somebody, well, we know who it is, ended up recording the plea and put it up on social media. Is there any way you can make a statement real quick that anybody, that they cannot record this or even put it up on social media? Would you, if you're comfortable with that, I'd appreciate it. I just want to make sure that does not happen again.
Ms. Arnold, anything you'd like to say about that?
Judge, we would agree that would be appropriate.
All right. as it does indicate on the watermark on all of our YouTube streams, people should not be recording and reusing these streams in any way, including not posting them on their own social media. Suppose at this point I will leave it there. It just shouldn't be happening. And if the court needs to step in and deal with that, the court will.
Very good, Judge. I appreciate that.
Ms. Arnold, did you have any other additions, corrections, or deletions?
Judge, I don't, we'll just state for the record though, that we have no objection to the suggested corrections in the defendant's sentencing memorandum.
I'm not aware of a defendant's sentencing memorandum.
We received one. We received it, I believe, in the afternoon on Wednesday. Sorry, I messed up on the day because we had to take off yesterday. I don't know if Mr. Muad wants to put those on the record.
Yeah, from what I'm understanding, and Nikki, my assistant, is there, it was overnighted and emailed with the support letters. I think that same day, Judge. I'm not sure if you got it or not.
Did not apparently make its way to me.
Okay.
Mr.
Jones, did you get it from us?
I did get it. I got it on Wednesday, June 18th.
Okay, Judge, sorry, Chris, go ahead.
Oh, I was just going to say the court, Judge, you weren't obviously directly emailed, but I believe your staff was emailed that. I can send it to you if you need it.
Yeah, if you could forward that to me, Mr. Jones, I would appreciate that.
Okay, I'll do it right now.
Okay, and Ms. Arnold, you said you had no issue with any of those corrections, is that
That's
correct?
correct.
All right, so the court would modify the pre-sentence investigation report to be consistent with the changes requested in the defendant's sentencing memorandum. Okay, anything else on that point then, Ms. Arnold?
No, thank you.
And Mr. Mawad, did you have any other additions, corrections, or deletions that we have not discussed already?
No, Judge, thank you.
Mr. Mawad, does the pre-sentence report disclose any prior convictions in which there exist any known constitutional defects?
No, Judge.
Ms. Arnold, are people aware of any constitutional defects in any prior convictions?
We are not.
The probation officer has calculated minimum sentencing guidelines to be from 36 to 71 months. Ms. Arnold, do people agree with that computation?
We do.
Mr. Mawad, does the defense agree with that computation?
Yes, Your Honor.
All right. Is there anything then, Mr. Mawad, that you'd like to say on behalf of Mr. Higgins before the court passes sentence?
Judge, I've got a little bit to say, but I know Matthew has a lot to say. And you've read my pre-sentence memorandum report, so you can see why this plea was carved out with the assistant prosecutor. I think it is fair, and I think it is equitable. Matthew has been an excellent client. Mr. Jones did a very thorough review on the in the pre-sentence investigation report. I'm asking the court to consider a carve out for any supervised contacts with minors, but mainly his family members is what I'm talking about. He has a big family, and I think in the audience, if everybody want to raise their hands in support of Mr. Higgins, that would be great. And other than that, I've met the mother, met the whole family. We've had a long-standing relationship because of this case, and Matthew is going to do very well on Mr. Jones's requests. I'm just hoping that the court would carve out that exception. I'll leave that up to Mr. Jones to comment and to Ms. Arnold. The only other thing is, and Mr. Jones and I did talk about this, the issue of the school zone. I know the federal courts have held it to be unconstitutional, but I know that MDOC, the policy throughout the state, actually, because I've had these other cases in other counties, is to continue with that contact. I don't think he lives in near a school zone, so I'm not sure if that applies, but I just wanted to point that out. Other than that, Judge, I think Mr. Higgins does have something he would like to read to the court.
All right, Mr. Higgins, is there anything you'd like to say on your own behalf before the court passes sentence?
Yes, Your Honor, I did write a statement, if it's okay if I can read it to you. To the court.
Yes, go ahead.
Okay, thank you. First and foremost, I want to thank the court and Your Honor for giving me the opportunity to speak today. I want to thank the prosecutor, Ms. Arnold, and my attorney, Eli, and his assistant, Nikki, for all the time, hard work, and attention that they've dedicated to my case. I'm very grateful. Your Honor, a lot of what has been brought up or said about me and the type of person that I am until this point has focused a lot on my history of drug addiction. I understand my past will always be a part of me, but I would like the court and Your Honor to know a little bit about the person I've become today. I've successfully completed a drug treatment program in April 2017, and since completing the program, I have not relapsed or turned to any sort of drug since. Following my release from the program in 2017, I completed my probation without any violations and was released early for following all stipulations and paying my fines as requested. I received custody of all 5 of my children very shortly after returning home in 2017 and will be officially 9 years sober in just a few days on June 23rd. I have made many mistakes in my life that I'm not proud of, that I have paid the consequences for severely and regrettably. But those mistakes have made me learn so much about life and is what made me become the man I am today. My past has made me humble and grateful for life. I don't take things for granted because every day is precious and a blessing. The biggest unforgettable and most regrettable thing that has happened in my life was my addiction. My addiction took me away from my children and my family for several years that I will never be able to get back. For the past 9 years, I've made it imperative to be the person I was supposed to be and to put 100% effort to be a good man and father. I have successfully started a painting and home remodeling business in 2017 till now that I have worked extremely hard to establish. I have received awards and certificates for being a part of rebuilding Detroit and remodeling homes for families in need throughout the Detroit area. I was able to open a storefront in Lincoln Park. I was able to rent 2 beautiful homes, later buy my first home for me and my children with 10 acres of property in Onstead. Most importantly, I would have not been able to accomplish everything that I was able to do and the support of my children and myself without my mother. She deserves recognition for everything she's done for me and my children. I'm extremely grateful for everything she has done and never given up on me. Excuse me, Your Honor. I love you, Mom, more than words can express. You are an amazing person. My biggest accomplishment was being a full-time father. That was the most rewarding of all. I dedicated my life to my children and to helping them thrive every single day. I wanted to be able to care for them and be able to provide for them with whatever their needs were. I wanted to be a good role model for them and to show them that to succeed, you must work hard and your hard work will be rewarded. I feel my children and I grew great relationships and bonds. Even though we've been apart, I hope they still remember all the great times we've had together as a family. There's not a single day that goes by that I don't think about my children. And all the fun we had together and the experiences we'd endured together. I miss all their laughs, their jokes, their smiles on their faces, their silly impressions. When they would get sad, I would try to cheer them up and encourage each other to do better every day. I miss their excitement on their faces when I would come home from work after a long day, and 1, 2, or all of my kids were trying to beat up Dad any chance they could. I did whatever I could to let my children know that they were loved, cared about, and appreciated. I would let them know that all the time, every day. I was actively involved in their schooling, homework, school activities, like school plays, concerts, bands, sports, and whatever other activities the school would perform. I would show my support. I was actively involved in their teachers and staff. I wanted my children to know that they had endless opportunities, and whatever they set their minds to, I would help them succeed in any way I could. My children and I actively did things together and were around family all the time. We went on vacations, family get-togethers, amusement places, parks, playing sports together. Those are memories that I'll never forget and miss so much. I love my children with all my heart and soul. There's no words emotionally or mentally of how much I miss them. It hurts and it will continue to hurt not having them in my life. All I want is the best for my children. I pray every day that God will be with them to help guide them every step they take. I'm no means a perfect person or a perfect parent. There's no such thing as a perfect parent, but I certainly tried to be and try to make up for lost times when I wasn't there for them in the past. My children did not ever deserve to be in a tug of war between their mother and I over the years that has made them not know who to trust or rely on. I wish I could go back in time and change things, but I cannot. Your Honor, I have learned a lot from this experience and would be putting a different perspective on my life and how to move forward. Every day will be challenging emotionally without my children in my life, but they will always be in my heart. I will be fulfilling my days, dedicating my time rebuilding my business to succeed even greater than it was, and to potentially open a storefront once again. I will be also doing projects at home. I will be enrolling and taking courses to pursue gaining my GED. I will also be enrolling in college to gain a degree in business that will help me with my business to be more successful. I will be attending church regularly with my family, and I want to thank my family and friends for all their support, for you all know the person I have become over the years and the man that I have become today. Thank you, Your Honor, for taking the time to listen to me today. This has been a life-changing experience and has made me open my eyes even more to the mistakes that I have made and that I have learned from. Thank you, Your Honor.
All right, Ms. Arnold, do the people wish to be heard before sentencing?
Briefly, Your Honor, I did want to read the victim's statement about the harm caused by the crime into the record, and then I wanted to make some comments. This is from the victim. She states, "My own father sexually assaulted me for 6 years of my life. I will never be the same. I just feel broken. He broke me. I don't trust anybody. I'm on medication at 13 years old." I want to state to the court, this is one of the more difficult cases I've dealt with in almost 30 years of prosecution. There's hundreds and hundreds of pages of court records involving this family. Child protective proceeding involvement before Madison was even born with her older siblings. There are a lot of allegations of abuse by the children that are then later recanted, mostly regarding their mother. The evidence in this case was quite complicated, lots of text messages, social media information, police reports, and Mr. Muad and his legal assistant Nikki did tirelessly comb through that information and sent me hundreds of pages of additional things to look through. At the end of the day, I think the plea agreement does effectuate justice, and I do believe that Mr. Higgins did sexually assault his daughter. I believe the recommendation is fair. As to the unsupervised contact with minors, I think the court knows, and Mr. Muad and I know, that an order that just supervised contact, an order that just allows supervised contact with minors is often violated. So I would be concerned with an order at this time that just allows Mr. Higgins to have supervised contact with any. I would suggest as an alternative that he complete his jail sentence, which he should be done pretty much. And then when he's out, he'd be placed on probation. I'm sure Mr. Jones, pursuant to the plea agreement, I'm sure Mr. Jones will if he is placed on probation, order or request appropriate terms, including sexual assault, counseling of some type. So I would ask that we table the request for supervised contact with minors at this time. We allow Mr. Higgins to have an assessment of some type and start therapy, and then revisit that, and at that time craft an order perhaps involving which minors he has supervised contact with and who will be doing the supervision. But I think a blanket order at this point would be inappropriate. Otherwise, I just ask the court to follow our recommendation.
Judge, to make it easy for the court, I don't have and Matt trusts me. I trust Mr. Jones implicitly. And I do know that it's usually his policy, before we even get into that, to have some type of therapy. And I want Matt to understand that it'll come a time where that will ease up, but I'm going to have to agree with the prosecutor on her statement. And that's just the way I am, Matt. Don't get mad at me. But Mr. Jones is the person that you have to satisfy at some point in time in order to request supervised visitation. And I've known Mr. Jones a long time, okay? You understand how that works? Okay.
Yeah.
All right.
Okay, so I have, aware of the plea agreement in this case, but there's been some discussion about a recommendation on probation terms.
The plea agreement just recommends a term of probation. Sentence agreement between the parties was a year incarceration
Right.
followed by a term of probation.
Right. I'm trying to determine whether there is a recommendation from the probation officer that has probation terms in it, because you have been discussing some, and the recommendation that I have is would be a prison sentence that's consistent with the guidelines. But it sounds to me like there's been something else has been prepared in the meantime.
No, we haven't spoken with Mr. I don't believe Mr. Jones prepared probation conditions based on their recommendation, but assuming the court does follow our sentence agreement, I believe Mr. Jones would request standard sex offender probation conditions, which would include an assessment and some sort of counseling program.
Okay, I just wanted to make sure that there wasn't a document that had been prepared that I hadn't seen.
Yeah, no, there hasn't.
All right, in determining the appropriate sentence in this case, the court has considered the seriousness of your offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the report and recommendation of the probation department, as well as what has been said on the record here today. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, vindication for the law and the protection of society. Mr. Higgins is 40 years old, has been convicted in this case of 1 count of second-degree criminal sexual conduct. He does have 3 prior felonies and 2 prior misdemeanors. There is in this case a sentencing agreement that is for a term of probation with the first year in the Lenawee County Jail. I do recognize that that is a departure from the sentencing guidelines, which resulted in a prison guideline of 36 to 71 months. I believe that for the reasons stated on the record here, both by the prosecution and by the defense, that because this appears from an evidentiary standpoint to be a difficult case with high stakes in either direction, that the agreement that has been worked out between the prosecution and the defense is appropriate and more proportionate to this case than imposition of the sentencing guide. So I am going to implement the agreement. It will be the sentence of the court that Mr. Higgins served a period of probation for 5 years with the typical conditions of probations that apply in criminal sexual conduct cases. Those would include that he participate in an assessment as directed by Mr. Jones, that he participated in counseling that would be recommended as a part of that assessment. And as directed by Mr. Jones, they did not have contact with minors. And with respect to that issue, I understand that Mr. Moat and Mr. Higgins are accepting of that provision at this point, with the understanding that I'd be willing to look at that, or Mr. Jones would be willing to look at that going forward, depending upon how things play out. It's exactly how I think it should be handled. I think that I don't have issues working with people where a track record can be established that supports that, but I need to see that track record first. That's just how. You must also remain active on the Michigan Sex Offender Registry for life. There is a $130 crime victims' rights fee, a $68 state cost, a $30 per month supervision fee. That fee would be increased to $60 per month if electronic monitoring were required. There's also a $750 court cost and a $60 DNA fee.
I think credit, Judge, did you say credit?
Yeah.
For okay.
I don't believe I did. Thank you. So you must also serve 1 year in the Lenawee County Jail. You do have credit for 329 days served. You do have the ability, Mr. Higgins, to request an appeal of your sentence. We're going to send to you 3 copies of a notice of right to appellate review and request for appointment of attorney form. When you get that form, you need to sign 1 copy and return it to the court. That just indicates that you received your copies of those forms. If you want to appeal your sentence, you need to fill out the remaining portion of that form and mail it to the address listed in the form within 42 days. Do you understand that, sir?
Yes, Your Honor.
All right. Is there anything else we need to address from the people?
No, thank you, Your Honor.
Mr. Wand, anything else from the defense?
Mr. Jones, do you want him to meet when he gets out of jail? Like, or how do you want to make contact with, or how do you want Matt to make contact with you?
Yeah, when he gets released, I'm not sure. I mean, he's got to be pretty close on that 1 year sentence. So
Right.
when he does get out, come up to our office. If I'm not there, they will get in contact with me, and then we'll go from there. But if he gets out over the weekend, come in on Tuesday morning at 8 a.m.
Okay. He may get out today, but
Okay.
I'm not sure. But okay, Matt,
If he
when you
gets
get
out,
out,
if he gets out today before business hours is over, he can go up to the office, get my phone number, and make sure he makes a phone call to me.
okay. All right.
Thank you.
Excellent. Thank you, Judge. Thank you, Ms. Arnold, Nikki, Matt, and Mr. Jones. I appreciate it. Matt, Mr. Jones is wonderful to work with, and you got to understand, and I'm just saying this for the record because I've known him long enough. He's got to get your trust first before we get into the other issue. Okay?
Yeah, he's not going to have no problems with me.
Okay. Fair enough. Thank you, everybody.
Thank you.
Judge, can I add one more thing or just clarify?
Go ahead.
I just want to make sure. So I know because the recommendation was prison, so we went to probation terms. Can we have all the standard condition and probation terms on there as well? Not violating any criminal law, substance abuse, the normal standard probation terms as well.
Yes, and thank you for reminding me of that. Those would all be included and all apply also.
Okay. Thank you, Judge.
Thank you, everybody.
Thank you.
Okay, Mr. Higgins, you can let the officer with you know that you are done with court then.
Thank you, Your Honor. I appreciate it.
Judge,
Yeah,
I'm here on Jesse Hurst. You haven't did him, right?
no, I have not.
Okay, I'm covering for Tom today, so I'm here. I'm just listening, okay?
Okay, Mr. Fry. I don't. He hasn't been printed, which I think is why he was here today. Do you know if they take them to the jail?
I asked them when I was in the back, Your Honor, and they told me they haven't, and they were planning to do it after, and I said the judge might have a problem with that. But I'll leave it up to the court's discretion.
Let's send it. I guess just bring. Arraignment. Yeah. This is file 25-22182-FH, People of the State of Michigan versus Jesse David John Hurst. We are here today for a sentencing hearing. In this case, we are proceeding today in person. Mr. Fry, would you like to place your appearance on the record?
Yes, good morning, Your Honor. Brian Fry, appearing for Jesse Hurst.
And sir, you are Jesse David John Hurst?
Yes, sir.
Mr. Hurst, have you had an opportunity to read and review your pre-sentence report?
Yes, sir.
Have you had an opportunity to discuss that report with Mr. Fry?
Yes, sir.
Are you satisfied with Mr. Fry and the advice that he's given you?
Yes, sir.
Do you wish to explain or challenge the accuracy or relevancy of any of the information that's in your pre-sentence report?
No, sir.
Mr. Fry, are you aware of any additions, corrections, or deletions?
No, Your Honor.
Does the pre-sentence report, Mr. Fry, disclose any prior convictions in which there exist any known constitutional defects?
No, Your Honor.
The probation officer has calculated the minimum sentencing guidelines to be from 0 to 11 months. Do you agree with that computation of guidelines?
We do agree, Your Honor.
Is there anything you'd like to say on behalf of Mr. Hurst before the court passes sentence?
So, Your Honor, Mr. Hurst, this case is a little bit older. It took a little bit to get charged. He's actually serving a prison sentence on a case that occurred after this one that made its way through the courts a little bit quicker. We do have the sentencing agreement in this case that if the judge was, or if the court was to impose any incarceration. It would be served concurrent with the term he's already doing in prison with NDOC. His guidelines were 0 to 11 months. He had no prior felonies until he was convicted of a few felonies all right in the same time period, this one here, and then some in Hillsdale County where he's currently serving his prison sentence out of. When he completes his prison sentence, he will be on parole. If he is released, or if he's not released, he'll do the maximum of that sentence. Obviously, we don't know whether he will be approved or not approved for parole, but if he is approved and released on parole, he will have to abide by the terms of his parole at that point in time. As far as I could tell on the recommendation, because there's not prison guidelines in this case, it was for probation. We would ask that the court just order time served at this point in time in this case, because his other case will put him on parole, and it doesn't seem to be beneficial to either have him in prison or on parole plus probation in Lenawee County when he's not even from Lenawee County. This was a case where Mr. Hurst freely admits that he had a drug problem, an issue with drugs, and he was asked to give someone a ride and paid in drugs for giving that ride, and they were found with quite a bit of drugs on them. But Mr. Hurst has certainly taken responsibility for his actions in that incident, which lands him here today. But he can certainly stay clean in prison and get some help there. But we would ask that the court follow the sentencing agreement and the recommendation from the probation officer. In this case, it does seem appropriate based on the circumstances that Mr. Hurst is facing and the circumstances of his offense. Thank you.
And I'm sorry, Mr. Fry, the agreement is just that any incarceration is concurrent to what he served.
Correct, Your Honor. That's all the sentencing agreement.
Just wanted to make sure. Mr. Hurst, is there anything you'd like to say on your own behalf?
I just would like to say that I apologize for what I did, and I know that it was wrong. And I would like to just thank Mr. Fry for all of his advice, and that's it.
All right, Ms. Teskey, there appears to be a discrepancy in the PSI between the recommendation on page 2 and recommendation narrative.
Recommendation on page 2 of the 145, Your Honor.
So the second page of the document.
Okay.
It says it's respectfully recommended that the defendant be sentenced to probation for a term of 3 months. And then
Where? I'm not seeing that, Your Honor. Where do you? May I approach?
Yeah.
Okay.
Is that what yours says?
That's what mine says, Your Honor. Yep.
Mine does not. Mine says. So you don't have the same one I do? Mine says 3 years. Or 11. Mine's 5:15. So. He originally recommended 11 months to 10 years. On a 0 to 11, which would make sense.
Okay, so I have the most recent version.
Yes.
Which I guess that's the important thing.
Is that the version that I have, Your Honor?
Yes, yours says 3 months. Correct?
Yes, correct.
527.
Okay. Yes, that's what I have.
All right.
Either way, I don't think, Your Honor, that it's probably best to put the defendant on probation and at the same time that he's in prison. So I think that, you know, the 3 months probation, Mr. Moore recommended is appropriate.
All right. In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, report and recommendation of the probation department, as well as what's been said on the record here this morning. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, vindication for the law, and the protection of society. Mr. Hurst is 30 years old, convicted in this case of possession of methamphetamine, is currently serving a Michigan Department of Corrections sentence of 1 year, 11 months to 5 years. And in light of that, I don't think that a probation term of 3 months is really would accomplish anything since he would be incarcerated with the Michigan Department of Corrections the entire time. Guidelines here are 0 to 11 months, and that does suggest that would suggest under the guidelines that a probation term is appropriate, but I think given the unique circumstances of this case, that Mr. Fry's suggestion of time served is probably the better approach, and Mr. Hurst will just serve his sentence on his other cases. So going to be the sense of court that Mr. Hurst served 98 days with credit for 98 days served. This file. Mr. Hurst, you do have the ability to request an appeal of your sentence. The bailiff's going to hand to you 3 copies of the notice of right to appellate review and request for appointment of attorney form.
Your Honor, I think we still have to order crime victims' rights and state costs.
Thank you. There is a $130 crime victims' rights fee and a $68 state cost. You need to sign the top copy of that, Mr. Hurst. That just indicates that you received your copies of those forms. If you want to request an appeal, you would need to fill out the remaining portion of those forms and then get us the new form within 42 days. Do you understand that?
Yes, Your Honor.
Okay. And you do still need to be fingerprinted, so I think they're going to take you across the street to the jail and just make sure that your fingerprints before. Thank you.
Thank you, Your Honor.
Thank you.
You need an order for the fingerprint. Mr. Brooks and Ms. Higgins come back to you. You have Mr. Lincoln share. That's okay. You can pull that. Brooks. You have to stay, sir. Looks stiff. It's got.
Okay. Oh. Just like 3 times.
All rise. Circuit Court is in session. Good morning. I apologize for the delay.
Oh, yeah, no problem. Sorry for ruining the whole Zoom thing and coming to person. I just was already down here and I wasn't sure that I'd have a spot to Zoom.
Okay. This is This is file 20-503-FC, 22-630-FC, People versus Dustin Durbin. File 22-534-FC, People versus Thomas Hernandez. And file 20-433-FC, People versus D'Angelo McWilliams. We are here today for hearing on several motions dealing with the request for stay of proceeding and modification of bond conditions. We are proceeding today partially in person and partially by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Palapu, who's here in the court.
Good morning, Your Honor. Melissa Palapu on behalf of the people. And regarding the Dustin Durbin matter.
Good morning, Your Honor. Assistant Attorney General Melanie Smith on behalf of the people regarding the Hernandez and McWilliams matters.
Good morning, Your Honor. Alexandra Peterson on behalf of the people. I'm appearing on both files today.
Good morning, Your Honor. William Amadeo, P76194. On behalf of Mr. Durbin and Mr. Hernandez, we both consent to Zoom, and thank you for allowing the Zoom. They are both present in Zoom, Your Honor.
And Douglas Gucher on behalf of D'Angelo McWilliams, who's present via Zoom.
Okay, why don't we start with the motion for stay. So, Mr. Gucher, if you have anything you'd like to say about that, you can do so at this point.
Yeah, the motion for stay is more formality. I believe we met after you were appointed in 2023, maybe in December or the beginning of the winter of 2024 in chambers. We discussed that the motion was pending before Judge Slay when you were assigned the case. That was scheduled and heard in February, but at that meeting, we discussed all parties that regardless of the outcome, the other side was going to appeal the case. Because of the way it was submitted and the hearing that we had with, I didn't ask for the stay in the motion itself, but that was known to the parties, I believe at the time. We've been getting along pretty well up to this point. I believe the last time we had a motion hearing, it was brought by the Attorney General's office. You ruled in our favor. They asked for a brief stay so they can contemplate an appeal, which we agreed to. We knew the circumstances of this. In this case, they're opposing the stay. I think the stay is appropriate given that the appeal will be filed next Tuesday. I don't know how long the Court of Appeals will take to decide that issue of whether or not they're going to accept it or not. But if the court wanted to put a 90-day stay on this case, just so that the Court of Appeals can take a look and see if we have an answer from them on whether they'll even accept the appeal, I think that would be appropriate given how this case has progressed. But as a matter of formality, the stay was the two travel requests that were made because if a stay is issued in this case, it wouldn't have a judge to discuss the issues with because the travel wasn't planned until later in the year in August, at which point in time, the last appeal I took last May on a criminal case, during the case, I filed it in May. The Court of Appeals, I don't remember when they agreed to take the case, but they did. They heard it on December 12th and they gave a decision on December 18th. So it took about 6 months. So that's why the motions were filed in the way they were. That's all that I have to add, Your Honor. Thank you.
Okay, Mr. Amadeo, anything you want to add?
The only thing I'll add, Your Honor, is we did grant the AG stay, and I didn't think this was going to be a big issue. I just want to have every opportunity to advocate for my client. So I'll stand behind Mr. Gucher's motion. Thank you, Judge.
All right, and I don't know who from the Attorney General's office is.
I'll just briefly, Your
Go
Honor.
ahead.
The people do not object to not setting a trial date. Will the they are appealing the ruling, but I don't think it needs to be like a stay for the entire case. I think we could still handle other motions and move forward in that respect, and that would still give them plenty of time to do their appeal and move their case forward that way. I just don't think it has to stay the entire proceeding, and that's the only objection by the people. I think we can still move forward on some aspects and just hold off on the trial date.
All right, Ms. Peterson or Ms. Smith, anything else?
Your Honor, I think Ms. Palapoo is correct. I don't believe that this court needs to lose subject matter jurisdiction over the whole proceeding while we wait for an answer from the Court of Appeals. I think that the motion to stay is perhaps just maybe a little premature. We don't even know if the Court of Appeals is going to accept the case, and we'd like to continue moving this matter forward. Thank you.
All right. As has been indicated, there is not a trial date set currently, and due to what I know about my calendar over the next 6 to 8 or 9 months, I wouldn't anticipate being able to schedule a trial date in that time. I suspect that this will be a lengthy trial. We haven't had those discussions yet. But given the fact that I just literally went through week by week with a couple of attorneys trying to schedule a civil case, I know because of some trials that are already on the books, one of which is going to take about 3 months, that there likely isn't going to be time to schedule this until probably April or May of next year. I guess let me ask the AG representatives, how long, when we set this for trial, how long the time are we looking at?
So in regards to the Dustin Durbin matter, there's 11 victims. So I do expect it to be quite a lengthy trial, just because you have at bare minimum at least 12 or 13 witnesses, but you're going to have more for all the evidentiary proof. So I believe, speaking, if I could ask Mr. Amadeo, I mean, do you think like a 2-week trial, Mr. Amadeo, or a 3-week trial?
I think 3 weeks is probably safe, Melissa, because when we were in Washington, they were planning a month just to be safe.
Okay.
But I think 3 weeks would be safe. I know that's a big ask for the court, but we have a lot to go through. If it does get to trial, it's going to be pretty lengthy.
Yeah, I would concur with Mr. Amadeo. Just there's so many witnesses.
And I guess maybe I should ask a more basic question, because I came in the middle and I don't think we've had logistic discussions. Are these going to be tried separately, or have they been consolidated? Is there going to be an issue with respect to consolidation?
So the people are going to move to consolidate the 2 Dustin Durbin cases, but my understanding, based off my knowledge of the facts, is that Hernandez and McWilliams is one case, but that is separate from the Dustin Durbin matters, and I do not believe there'd be a basis to combine those. And I don't want to speak for Mr. Amadeo, but I think that probably sums up the facts. Correct, Mr. Amadeo?
Yeah, I would agree. I don't see Dustin and McWilliams and Hernandez being joined. I think Durbin's going to be by itself. I do think the 2 Durbin files probably could be combined, but I think they're going to be. We're looking at 2 separate trials at least. Even if we combined the 2 on Dustin, we would still have Hernandez and Williams separated. That's my feeling. I mean, I think you agree with that, right?
I agree with what Mr. Amadeo said, but I can't speak to McWilliams and Hernandez. I don't know if those 2 are joined or separate. I would leave that to Ms. Smith to speak to that, because I really just don't know the facts of that one.
Understood.
Oh, I'm so sorry. Those 2 files are already combined, Your Honor. I'm still in the process of going through and refreshing myself on all of the procedure, but I did see that order in there this week as I was looking through the file.
Okay.
And with respect to timing, I would somewhat defer to Ms. Peterson and defense on that. As I said, I've just been on this file a little over a week officially, so I don't think I'm in the best position to determine what the proposed length would be. But my guess would be around 2 weeks as well. Ms. Peterson, could you assist me?
That's an accurate estimate of how long I believe the trial would be. If that's fair to say to Mr. Gucci or Mr. Amadeo.
Yeah, I think Alex has been on this case for a while with us. I think 2 weeks makes sense. We did have that one issue though, and Alex, correct me if I'm wrong, but remember we were talking about the juries. I think we're going to have one jury for Hernandez and Williams, but that was an issue we had talked about in Washington, which could change the time frame. But I do think 2 weeks is a safe play on these. I don't know your thoughts on that, but remember we had that one issue before Judge Slay. Do we have one jury or two juries?
Right, I'm not sure we ever
And-
settled on that one, if I recall.
Yeah, and I'll turn to Mr. Gucci on that, but I think one jury is what we all wanted, both sides, I believe. But it's been a while since that issue's been addressed.
Okay. Well, obviously I can't schedule anything today because we need to coordinate that with the people in Washington County so that we have a courtroom available to us, which in my experience usually makes things take longer because we now have another entity's schedule that has to be accommodated. I think given the length of time that we're talking about, that there doesn't appear to me to be any need for a stay. I think that the Court of Appeals will have ample time to deal with the appeal that is going to be filed before we would approach anything close to a trial date. And in my experience, when there is a trial date, the Court of Appeals typically does a good job of issuing their ruling enough in advance of that to allow the trial to move forward. I also think that we should continue to have the other hearings that need to take place in this case so that we can get these cases prepared and ready for trial at given the circumstances, the earliest reasonable opportunity. Obviously, these are very old cases, and we are at a time now when I think they need to be put on the calendar and start moving forward to finality. So for those reasons, I would deny the request for stay. And Mr. Gucci, you had also filed a request to modify bond conditions. I guess I've got two, and they're both with respect to Mr. McWilliams. Am I understanding that correctly?
Yeah, when I filed it last week, in talking to Mr. McWilliams, he had two requests. I believe there's only one request at this point in time. The work one looks like it's not going to be not going to come up. It looks like he's not going to get that position, so it's going to be a non-issue. So the request for the travel out of state, I'll withdraw, or withdraw as it relates to the work request.
Okay, so that would leave the one that for August 10th through 15th.
Correct. And it's similar to the two previous ones that had been stipulated to in the past, but in response to the motion that was filed, they're now asking for a GPS tether to be placed on him to allow him to travel. And if that's going to be the condition, he doesn't want to travel with a GPS. I mean, there's no reason for him to, excuse me, there's no real reason for him to be placed on a tether 5 years after bond was set. These issues were addressed, excuse me, by Magistrate Fink when the bond conditions were set. These allegations that we're facing were 4 years old in some cases when the charges were issued. They occurred at a frat house when he was in college. He has no criminal record. He's appeared at every proceeding. We arranged to turn himself in when the warrant was issued. He had cooperated with the investigation. I mean, and since there's been no violations and he's appeared at every proceeding. The purpose of the bond is to assure both public safety and that the defendant appears at all proceedings. And there's been no issue, no history of any violations of either criminal law or failure to appear. And so, and like I said, the prosecutors and judges that have had this case over the years have reviewed the matter and allowed him to travel out of state on 2 previous occasions by stipulation. And now all of a sudden they want to take this punitive measure, and it is punitive, and it's without justification. So if the court is going to require a GPS tether if he wants to travel, then just deny the motion. I don't want him to travel. I don't want him to have to wear a tether for the next year and a year and a half until we get a trial date. That was never contemplated when I filed the motion. I never anticipated they would respond that way.
All right, Ms. Smith.
Thank you, Your Honor. In taking these files over, I'm of course starting at the very beginning and learning the procedural history from day one of these cases, as is required, so that I can handle these cases knowledgeably and thoroughly. I was extremely concerned about this case as I began reviewing it, understanding that it started in the height of the COVID-19 pandemic in September of 2020. When the defendant was arraigned, he actually was not even arraigned in Washtenaw County. He was arraigned from Livingston County for a reason for which I'm not sure. And there seems to be no explanation of that reason in the record that I can find. He was given a $50,000 10% bond, which he posted. But in the remainder of the pretrial release orders, there was no conditions whatsoever that were placed on the defendant, which is just extremely concerning to the people. These are very serious allegations, regardless of whether or not it was a delayed disclosure or college location. They're very serious in nature, Your Honor. They're some of the most serious charges that can be against a person in the state of Michigan. And so for there to not be any pretrial release requirements on the defendant, I think is negligent, truthfully. I have never seen a felony pretrial release situation in which there are 0 requirements on a defendant. I was hoping that I was mistaken in my belief that that was what had happened based on review of the records. So I scheduled a meeting with the director of Washtenaw County Community Corrections on Wednesday, hoping that she would be able to fill me in. She reviewed what she had, and Mr. Williams is not even in her system, Your Honor. She has no file for him whatsoever, has never interacted with him. He's never been required to check in with pretrial services a day on this case. Of note, the other 2 defendants are checking in with pretrial services, I believe at least weekly. They do have tethers. They have the normal, reasonable pretrial release conditions that, again, in my experience, every defendant facing a felony capital case is put on. So the fact that other than no contact with a couple of people is the only condition for which this defendant has, I am greatly concerned by that, Your Honor. And I am simply asking for you to take a look and in your judgment, contemplate pretrial release and impose the conditions for which you believe are appropriate. The people believe that a tether is appropriate based on the situation, the case that is pending, the seriousness, nature, and the other factors that are contemplated in MCR 6.106. So I'm just asking this court to go back and do what the court should have done many years ago. Thank you.
Okay.
Your Honor,
I don't think any rebuttal argument is necessary at this point, Mr. Kutcher. The court also has significant history or track record of Mr. McWilliams. He's been on bond in this case for since 2020, so 5 years, maybe a little more, maybe a little less. There's no indication that there has been any issue with him appearing at court hearings or doing anything at all that would be problematic. And so I think there's a track record there that the court is able to rely on. So I would grant the motion to approve the travel for August 10th through 15th of 2025. With respect to the request for additional bond conditions, I think there are a few very basic ones that would be appropriate and I think are required, maybe not required, but would be appropriate in any case, and that's that he personally appear for any examination, trial, sentencing, or any other court hearings, that he abide by any judgment entered in the case, that he not leave the state of Michigan without permission of the court, that he not commit any crime while released, and that he immediately notify the court in writing any change of address or telephone number. In looking at the documents that were available to me in preparing for this motion, I didn't even see those conditions, which I think are appropriate. But I don't think that a GPS tether is necessary in this case because, again, there's been a long track record of Mr. McWilliams appearing, and there just isn't. I don't see any reason to make a further modification at this point because he's appeared at his court hearings and there's no indication that he's done anything inappropriate while on bond. So to the extent there are other requests to modify the bond, I would deny those. Is there anything else that needed to be addressed today?
Well, Judge, I have two motions for bond modification, but if you're just talking like Williams, then for Hernandez and Durbin, you're on a couple.
I haven't received your motions for bond modifications, Mr. Amadeo.
They were sent over. Hold on one sec.
I'm not sure, Your Honor, when they were originally sent over, but I do know that your office did forward me a copy because I wasn't served with them. So I did get a copy from your office. I don't know if it could be in your Wednesday emails.
They were originally sent on Friday at 4:28 p.m. is when I received Mr. Amadeo's motions. And it looks like Miss McGrain and Miss Clark were both on that email as well.
Judge, I just resent those to you.
Mr. Amadeo, what would you like to say regarding your motion?
For Mr. Hernandez, if I may start there, Judge. I'm asking for his tether to be removed. He had no tether for first couple of years of this case, and the AG's office, basically Kelly Carter, said if I ran the prelim, she was going to ask for a tether, which she did. That was 3 years ago, Judge. He came in from Arizona for self-surrender when Jessica Lowry asked him to. He's got an unblemished record in court. It's an unnecessary expense. He's never missed anything. I don't think the tether is necessary for Thomas whatsoever.
Okay, Ms. Powell?
That would actually be Ms. Smith.
Oh, I'm sorry. Ms.
Yeah.
Ms. Smith.
Thank you, Your Honor. The procedure, as described by Mr. Amadeo, is correct. Mr. Hernandez was placed on tether after the preliminary examination in September of 2022, based on the court's concern at that point after hearing some of the testimony, which it described as, quote, disturbing, predatory in nature, and beyond unconscionable. So the 50,000 10% bond was increased to a 250,000 10% bond, including the GPS tether, which the defendant has posted and has been on for the duration of this case. I understand that there's a generalized statement that he wants to be removed because it costs money, but we don't have any information as to why it's a hardship or why it's unbearable for him to continue paying for it. The defendant does not appear to be indigent. There's no reason that he can't work while on tether. The tether, frankly, is one of the very small things that the court and the people can do to provide some level of reassurance to the victims in this case who have been lingering and pending with the trauma of this case for 5 years, just as everybody else has. So to remove that layer of protection for them, I think is just not necessary. I think that it's appropriate that it stays ordered and that bond just be continued as is in this matter. Thank you.
All right, I don't have obviously the benefit of the analysis that the court made at the time that these bond conditions were imposed. Understanding at this point that it was done after the preliminary examination occurred, and given that, I don't think there's enough information in front of me right now to do an appropriate analysis to modify the bond. I understand he's been on his conditions and compliant with his conditions for an extended period. But I can't say that just having been on bond for an extended period is a good reason to modify the bond. So I would deny the request.
And I'll speak on Durbin when appropriate, Judge.
Go ahead.
So, Judge, following your lead here, I'm assuming you wouldn't take the tether off Dustin. The biggest concern with Dustin's case right now is he's not able to work. He's missed a family funeral already because he's on house arrest as well. Even in the Attorney General's response, they said they'd leave house arrest to the discretion of Your Honor. So at this point, I'm going to ask that he be released from house arrest just so he could work and keep the GPS tether on. Again, this case is going on for 5 years. He's never missed a court appearance. He literally cannot support himself right now. He lost his job at DoorDash by having house arrest. I have no problem in this situation, Judge. Do you think house arrest is overkill? He's never created a problem with bond whatsoever, and I do think taking him off house arrest would be appropriate.
Okay, I'm sorry, Mr. Amadeo, but your audio broke up a little there after you said overkill.
I think house arrest is overkill. He's just trying to support himself, and he's never had one issue with bond whatsoever.
All right. Ms. Bell.
Yes, thank you, Your Honor. If the request to remove the GPS tether has been removed and we're no longer considering that, if people do leave house arrest to this court's discretion, I would just ask that the other bond conditions remain the same, that he continue to check in with pretrial services, and that he remain on GPS tether and remain having no contact with any of the 11 complaining witnesses in this case. I do believe he is in extreme danger, considering there are 11 separate individuals who are stating that he has sexually assaulted them. So I would believe that those other conditions would be necessary to protect the public.
I guess I should say it out loud. To the extent we've talked about bond at all, I would, unless otherwise stated, all of the conditions in place would remain in place with respect to everybody. I think that this situation is slightly different than Mr. Hernandez with respect to the house arrest issue. I think that modifying that to allow him to remove the house arrest provision would be appropriate, so that he can have an opportunity to work and pay for the GPS tether, among other things. But I think that would be appropriate. So I would grant that request, but I would leave the remaining conditions in place.
Thank you, Judge.
Okay, anything else that we need to address today?
Nothing on behalf of the people for Mr. Durbin.
Nothing for Hernandez or McWilliams from the people. Thank you.
Just one housekeeping issue, Judge. If any other evidentiary hearings happen, just based on, I work in Washington a lot, I'd have no issue doing them in your court or on Zoom if there's no objection from the people. I think it's much easier to get into your court than it would be to get into Judge Kunke or Judge Slay's court based on what's going on with trial dockets right there. Obviously, the trial has to be in Washington. That's venue. But I think for any other hearings, your court would be appropriate if there's no objection.
All right, and I'm happy to do it either way. I tend to agree with Mr. Amadeo that things would work more efficiently if we do it here rather than try to schedule a courtroom time in Washtenaw County. But obviously, people are entitled to that if that's what they want to. So I'm happy to do it however everyone else wants to. Mr. Butcher, anything else from your perspective?
No, Your Honor. Thank you.
All right. If that's the case, then I think we're all set, and those here by Zoom can go ahead and log out.
Thank you, Your Honor.
Thank you.